Sorry?
He's got a mic over there.
Oh, right, okay. No, I don't mind. So. Okay. All right, hi everyone. Hello, thanks for coming out today. What I have here is, I suppose everyone knows what we're talking about. We know, most people know what's going on or have an idea. We know basically what a strawman is and the legal fiction and how a corporation is compelling us into slavery. So what we do is we go around and try to give people some solutions, because we can talk about the problems all the time, but once in a while we need some solutions on how to deal with this situation. So what we do is we try various things. The ones that don't work we leave alone, and the ones that work we put them in paper and then we share that information with people. So what I have here is just, I'm going to run through some of the stuff I've come across. If it's something you find useful, we encourage people to do their own research, because there's so much information out there. Not a single man or woman has all the information, so we just need to put all the information together and then use it and share it. So I'm going to start with, my agenda is going to be who you are, because that's where it stems from. If you don't know who you are, somebody's going to take advantage of you. So the question is, who are you? The second one is going to be between legal and lawful. We tend to get confused about legal and lawful. Something might be legal, but it's unlawful. So we need to understand that. And also I'm going to talk, I'm going to offer some solutions. So the first thing is, who are you? And how many people know who they are? So are you your name? Some people, or are you your profession? Because some people say, who are you? They say, I am a doctor, or I am John, but that's not who you really are. So people who know who they are, they know that they are a spirit. Because if you tend to believe that you're created by God, and God created man in his image, and God is a spirit. So you are a spirit who's experiencing life as a physical being, for the time being anyway, temporarily, and then you leave here and go somewhere else. So that's who you are. So you're not a name, and you're not your occupation, because occupation is, that's where your occupation is military. So you're under military occupation right now. That's why they can do what they're doing to you, because you're enemy combatants. That's the situation. So who are you? We say you can choose, either you're created by God, you can choose to use that premise, and like we say, your idea of who you are is what creates your own reality. So if you believe that you're created by God, you behave differently than somebody who believes that they used to be a monkey and then they became a man out of that. So that's the point. Why are you created by God? You used to be a monkey and then you became a man. And there are some monkeys right now which are still becoming people, or is that a different story altogether? So that's the question. Or are you the name on a piece of paper, which is Crown copyright? So birth certificate, all of them are Crown copyright. So it's not you. So are you a copywritten thing that belongs to the Vatican? Because we know register is Vatican. Everything to do with registration should be the Vatican. So every time you register something, it simply means that you give ownership to the Vatican. So are you that? Are you that piece of paper, Crown copyright? So that's what you need to decide. Once you decide who you are, then you know how to act. When it comes to public services, you have to understand what a corporation is and the status in law between a corporation and a living man. Authority, the ultimate authority comes from God, or they claim that they get the authority from God. So in the beginning, God created man and woman, but man is a general term, which is man and woman. So God created man in the beginning, and that's where the authority comes from. Then man created government. So God is there, government is there. God is there, man is there, government is there. So government can never tell man what to do, and man can never tell God what to do. And that's the reality. But the truth is that the public servants have made you believe that they have authority over you, that because they are government, they have authority over man. But that's not the reality. Man has authority over government because man created government. But the point is, right now, the government that you created has been sold to a private corporation. So it doesn't exist anymore. There isn't a government. What you have right now is corporations and trusts. So that's what you need to be dealing with. There is no government. It's an illusion. In any way, government is an illusion for the fact that it's a political creation. It doesn't exist. It exists in your mind, but if you try and find the government on a Sunday afternoon, you're not going to find it, because it doesn't exist. Or Sunday evening, it's not there. It's the men and women who use these positions to take advantage of other men and women. Simple as that. So we need to deal with the individual men and women who have taken a position of authority and they're abusing that position. That's all there is. But government does not exist except in your mind. It's a political creation. Right. As far as the crown is concerned, I'm going to go through the visibility of the crown very briefly. We go through this quickly so people know that there's divisibility. There's a duality in everything that we do in the public side. So you have the crown, which people need to know that the crown has got two faces. So you have crown, I think we spoke about it last time, but I'll go through it briefly again, quickly. So you have Her Majesty the Queen, Elizabeth, the second of the House of Windsor, and that's one, which is a natural woman, that's a crown as well. And then you have Her Majesty the Queen in right of England, which is the Crown Corporation of the City of London, is called Her Majesty as well. So when you see on your cigarette packets by appointment by Her Majesty, it's not the Queen, it's the Crown Corporation. So you need to understand the difference between the Crown Corporation of the City of London and the Crown, which is the woman, the Queen. The difference. When you're dealing with the Crown, you deal with the Queen differently than you would deal with the Crown Corporation. Simply because the Crown Corporation of the City of London by itself is an independent state. It's not part of England and Wales. I think we all know that by now. Same as the Vatican is not part of Rome or Italy. Same as DC is not part of United States of America. Those are independent states. So the square mile, the City of London, when the Queen needs to go into the City of London, she has to ask permission of the Lord Mayor of London before she goes in there. And she has to bow down to him and do all this ceremonial stuff before she's let into the City of London. So it's an independent country altogether, and it's got its own laws. So when it's trying to deal with you need to understand your status in comparison with them so you can deal with them properly. So those are the two crowns. It goes down to Her Majesty the Queen the Elizabeth, the woman, she's a defender of the common law, and that's the oath that she's taken. So the Queen Elizabeth is defender of the common law of the land known as England and Wales. The other crown, which is the Queen in right of England, that's the one that creates all the what they call codices, rules, regulations, and statutes of the Crown Corporation of the City of London. So these are the things you call statutes or acts of parliament. Those are created by the City of London, the Crown Corporation, you see. So common law is the law of the land that's been there ever since. The statutes created by the City of London, they create those every day, okay? So the statutes require consent. The common law doesn't. It requires you to breach the peace, and then the common law comes into effect. If you don't breach the peace, everything's okay. The statutes require consent. You don't need to breach the peace, but if you give consent, then they can apply the statutes on you. So that's the difference. Okay. Next one is constitutional. So the Queen, the woman, her powers are derived, the constitutional powers. So it goes all the way back to Bill of Rights and Magna Carta and all the stuff, the old established laws. That's where the woman Queen derives authority from. And then you get this other one, the Queen in right of England. It derives its authority by consent. So all the acts of parliament require your consent. If you don't consent to it, the act doesn't apply to you. Simple as that. Okay. And then private and public, I'll explain that as we go along. You have to understand, in the old days, there used to be something called public, which is public servants doing public things for the public, which is the people. Right now, there is no public anymore. Everything is private. All the companies have been sold. So everything, not a single company is publicly owned anymore. Now, as private companies, they're acting as businesses. A business is there to make profit. If it doesn't make profit, it goes out next year. That is it. So a private company, they're there to make money off you. So make sure that you don't give it willingly. At least let them work for it. Okay. So we know what the divisibility is. And common law applies to the living man or the living woman. Codices, rules, regulations, statutes apply only upon corporate or what they call legal fictions. So all the acts of parliament apply on legal fictions, only. The only reason that you believe applies on you, because when they draft their documents, they put something that looks like your name in all capitals. And because it looks like your name, you believe that it applies to you, and then you attach to it. It's called a joinder. And then once you join to that document, it applies to you. Because the legal world is a world of smoke and mirrors. It's about trickery and tricking people. So their doctrine is this: he who wishes to be deceived, let them be deceived. That's how they operate. So they won't give you any advice, and if they see you going to fall into a hole, they won't help you. They just observe and watch you fall in there. So that's how they operate. They have very little honor, as far as I know, or my experiences, right? So lawful is natural and real, in quotes, and legal is fictional. Or legal is fictional, sorry, and that's the illusion. So anything legal, remember, it's fictional, it's not real. Anything lawful, that's what you want to do, that's real. You want to abide by the law. If you remain lawful, then legal stuff, they can go, because legal, it requires a consent. Okay? So legal is a fiction. That's why it's a legal fiction world. The legal industry is not there for justice anymore. It's called an industry. An industry is there to generate profit. So when they talk about the legal industry, you have to understand that they're there to make money. That's why when you go to court nowadays, you're called a customer. Why? Because you're bringing in money. And that's all they want from you. You're a customer. So those terms, we'll go into terms as well. Everything is by definition and its spelling and how you spell a word. If you say a dog, then it means a dog. It cannot mean a cat. So we'll get into legal definitions in a minute as well. So that's the divisibility. You need to know which crime you're dealing with before you deal with it. Simple. If you need definitions, this helps. Definitions will help you very much in your defending any claims brought against you. Because if somebody says, for instance, you stole their dog, and in actuality you stole their cat, then the claim is false for the simple fact that what they're saying is not true. So when somebody says to you that you're a taxpayer, for instance, then you have to accept to be a taxpayer, and there's a legal definition of what a taxpayer is. For instance, when you're driving a car, you see, if you accept that you're a driver, that's a legal term, and then all these statutes will apply to you as a driver. But if you're traveling, it's a different thing as well. So when you get stopped and they ask you as the driver of the car, and you say yes, automatically there's a joiner there. You're doing commerce, you're trafficking. When you're trafficking, then you have to pay the people who allow you to traffic a little bit of commission. So they need their take, you see. But if you're traveling, you're not doing commerce. That's the difference. When you're traveling, you don't need a driver's license. When you're driving, you do. That's the difference. When you're traveling, you don't need insurance on your car. When you're driving, you do, because you're conducting business. Okay. So I picked up a definition. I'm going to read this so you can see clearly two definitions that I got to do with legal and lawful. For the definitions, if you look into Bouvier's Law Dictionary, or even Black's Law Dictionary, you'll get the definitions of what legal is and what lawful is. For me, I used what they call the Dictionary of Law from 1893, and it gives a pretty good definition. So lawful is this. This is what we want to be lawful all the time. So lawful is in accordance with the law of the land. That's what it says in 1893. According to the law, permitted, sanctioned, or justified by law. So lawfully properly implies a thing conformable to or enjoyed by law. Whereas legal is a thing in the form or after the manner of law or binding in law. That's it. The binding is the contract, you see. So it's in a form of law, but it's not real. The legal, that's the fiction we're talking about. So legal is opposed to actual. Legal looks more to the letter, and lawful to the spirit of the law, you see. So legal is all paperwork, whereas lawful is to the spirit. Now, all their false claims will fail on paperwork because all their documents are invalid for various reasons. They don't seal them, they don't sign them. Most of the time they don't even put their names on it. If you don't do that, that document is not legal even. So you cannot enforce an invalid document, but that's what they've been doing all the time. Every time they issue an order and you ask them, let me see it, and they refuse to give it to you. Why? Because it's invalid. It has to remain true to the letter. It's a contract. If the contract has got errors, then you have every right not to attach to it. So that's what it is, okay? So it also says, legal is more appropriate for conformity to positive rules of law, lawful for accord with ethical principle. So legal imports rather than the form of the law are observed, that proceedings is correct in method, that rules prescribed have been obeyed. That's all they do is procedure. So as long as the prescribed rules have been obeyed, they don't care. You see, they don't care about the spirit of the law. So legal is just about paperwork and procedure, you see. And then, okay, what else do you have here? Legal, he said, this is the Dictionary of Law in 893, says, legal is the antithesis of equitable, which is just the opposite. So anything legal is the opposite of equitable, and equitable being what? Fair and just. So the law dictionary says that anything legal is the antithesis of equitable and the equivalent of constructive. So every time they deal with you, they're creating a constructive trust. That's all they're doing. And once the trust has been created, then they carry on and execute it. Simple as that. Okay? So I'd say, how many people here are citizens of the United Kingdom? By show of hands. Citizens? No citizens? Not a single one? Oh, good. Because the reason for that is because those statutes apply to citizens only. Because corporate charges only apply to corporate citizens. That's why right now there's a lot of people being brought into the country because they have to create new citizens. That's why the country is full of new, fresh blood to be created as citizens. Once the citizens have been created, then the charges can be created and charged on the citizens. So that's what's going on now. Okay? But I'm glad there's no citizen in here. It's a different story. Okay, now, the fictitious public bodies cannot interact with natural man, as we said before, because there's an unequal status in law. Their corporation, which is a corpse, is C-O-R-P-S-E, or C-O-R-P, core. That's a dead, it's a corporation, it's a corpse. That's what a corporation is, it's a dead body. Because it's dead and you are living, they cannot deal with you. It's called unequal status in law. So how are they going to deal with you? What they do is they reduce you into a legal fiction. And that's they can charge you now, if you accept that you're a legal fiction. That's the entire trick. So you always have to remain true to who you are. Every time they bring their claims, you have to let them know that you're living. You're a living man or woman. You're flesh and blood and you have a soul, you see. And you're not a dead corporation, so their acts do not apply to you. And if they have any proof that the acts apply to you, then you want to see it. They never have any proof anyway. Okay? So by a show of hands, who knows what the law is? Yeah? What is it?
Law, natural law is what I follow as a man.
What's the law?
The law is do not cause harm into the law.
Exactly. That's it.
So
That's the law.
I learned that at school.
Exactly.
The playground.
Yeah. That is the law. Okay? If anybody tells you anything else, they're lying to you. That's the entire law. Everybody knows the law, except that we don't follow it. Okay? The law is this: do no harm to man or property. So don't damage any man, don't threaten them to damage them, and don't damage the property. That's it. If you do that, then if we all did that, then there wouldn't be any crime, will there? If everyone did that, everyone caused no harm to their fellow man. That's it. Period. So that's the law. Do no harm. If you do harm, then you've broken the law. Everything else is contract. Okay? Everything else, all this other stuff is they call acts. They're not law. Others they'll be called the laws of parliament. These things are called the acts of parliament. It requires you to act in a certain way for it to apply. Okay? That's it. So that's the law. We know what the law is. So as long as you haven't caused injury or harm to anyone, you haven't broken the law. Simple as that. Okay? It also says ignorance of the law is no excuse. Now we all know the law, so we're not ignorant of it. We just need to apply it. And how do you apply it? By just being a little bit brave, so that when a public servant approaches you and tries to convince you that you're something that you're not, you stand up and say, "Hang on a second, it's not like that." Okay? You're the servant, I'm not the servant. You're serving me, I'm not serving you. So I'm not accountable to public servant, they're accountable to me. And that's my approach anyway. It pisses them off, but I can't see it any other way. I don't know, maybe it's just me, but that's how I see it. He's the public servant, not me. I'm not accountable to him. I don't care if you call yourself a judge. You're not a judge until I see you sign the oath of a judge. By the way, incidentally, I'm going to deviate for a minute. These people calling themselves judges, they're not judges. They've lied to you. A judge is somebody who's taken an oath of allegiance that's going to be fair, you see. And it's a signed document that they have to sign under oath, you see. If it's a real judge, what you do is before the hearing, court hearing, 2 or 3 weeks before, you ask for the certified copy of the judge's oath. And once you get it, you attach that to your bundle when you file in court, you see. Then it's going to be fair with you. If you don't do that, they are not going to be fair with you. They're not judges, because when they're sitting in their magician's court or even county court, those venues can only deal with corporations. And when they're sitting down and dealing with corporations, they're not acting under their judicial oath of office. What they're doing is administrative, you see. It's being a clerk. But they cannot use their oath in a magician's court or a county court, because they're being a clerk, they're not being a judge. So they're not judges, okay? They're priests, by the way. Well, that's another story. Okay, so I'll give you what they use, what the bar guilders use. The bar guilders are the guilty people. The people ask you, do you plead guilty or not guilty? It doesn't matter how you plead. As long as you plead, you've accepted jurisdiction. So it doesn't matter. So the bar guilders, those ones, their motto is that no truth or fact shall be heard in a court of law. You see.
So you lie? So you have to lie in court?
No, you don't have to lie. It's just, you see, it's no truth or fact will be heard in a court of law, which simply means that those venues, when you go in there, you cannot talk about truth or facts. You won't be heard.
Well, then, so
You see, that's the trick. So that's the trick that will get you in there. So when you go into court and they ask you, why are you the driver of the car? Those are truth and facts. And you're talking about, no, I wasn't driving at 30 miles an hour, I was driving at 25 miles an hour. You see, you're going to lose your case because you're talking about truth and facts. When you go to those venues, what you want to talk about is this. By what authority do you have me in here? You see, before I can start talking about what happened, you need to identify who you are to start with and by what authority you have me in here, and then we can talk about what happened. But what they tend to do is they jump the first stage and just start adjudication. But it's 3 stages, well, I'll get to that here. But that's the point. No truth or facts shall be heard in a court of law. So when you go to those venues, you don't waste your time talking about truth or facts. You need to know by what authority they have you in there to start with and who they are before you answer any of their questions. Remember, they're the public servants, not you. They're there to serve you. You're not serving them. So before they ask you questions, ask them who they are, what's their name, and what's their role. Because the point is this, you are acting under your unlimited commercial liability. They are agents for somebody else. They're always limited liability companies anyway. What's limited liability? It simply means that. They're limited. You accept full liability. So if I'm going to accept full liability, and you're asking me questions, I'm going to ask you some questions as well, because you're acting under limited liability. You see, you're acting under immunity.
Well, I went to court and I asked the judges who were and whatever, and they wouldn't give me the name, the clerk wouldn't give me the name.
Right,
the clerk wouldn't give me the name.
right. If they don't give you the name, you don't recognize them as a judge. Simple as that. You see. So anything, any ruling that he's going to put across, you can avoid it, because you don't recognize him as a judge. If I came to you and say, listen, I'm a judge, me, here, just believe me. Okay, and I'm going to give you an order now. Why? Because I said so. I'm not a judge. I cannot do that. Same with him. He can say as much as he wants. He's a judge. But when he's sitting in a magician's court, he cannot use his judicial oath. That's the reality of it. Why? Because it's administrative. It's not judicial. The only oath he has is a judicial oath. You see. That's why you never see the oath. They never show it to you. He'll show it to you when he's doing a judicial work, because I've seen a judge's oath. There's one case we had in Leeds, which was to do with a child. The council were trying to take somebody's child, so we had to go to court and we asked the judge for his oath. And he actually produced it. I was shocked. That's the first one I've ever seen. Once in 8 years, you see. Because the trial was judicial, and he was sitting under his official judicial oath. When they're doing administration, they cannot use their oath. You see, that's why they never give it to you. So never believe someone when they tell you they're a judge. Never believe someone when they tell you they're a police officer as well. The police take an oath as well. I cannot come and arrest you. And if you ask me, are you acting under an oath? I don't know anything about it. I'm just going to arrest you because I'm wearing a school uniform and I have a radio. Big deal. Keep moving. You see. Anyone can wear a uniform. I can get it off now and go and arrest people and fine them. So the only thing he has is an oath and warrant. That's where the authority comes from. Not from his uniform. You see.
But often the police can't tell you their oath of office anyway.
Of course, because these guys were 25 years ago. You had the constables on the street, you could talk to them. Those are real police. The guys, the kids, we call them bacon boys in black. The ones who are running around the streets now, Hitler Youth, the new Hitler Youth, they have no oath. They're taught how to hit people with the head of the stick, but they don't know anything about the law, you see. That's the trouble.
They changed it recently, a few years back. They no longer take oaths, they now take attestations.
Well, you see, that's the point. When things stop being public and become private, then they can do whatever they want to do. The point is this, as long as they don't have an oath, they have no right to arrest you. Simple as that. So the first thing you ask him is, are you acting under your oath? If he doesn't have it, you don't get into any conversation with them, you don't contract with them. I think we went into some detail last time, I won't get into it too much right now, but we have the literature for it. We have the answers for questions to ask these public servants when they come to try and create a pretensive joinder with you. Okay? So, what we do is, we use maxims. So when they say no truth or fact will be heard in a court of law, in our paperwork we use maxims because maxims are stronger than statutes, because maxims were there before statutes. So, the maxims that I use is the simple ones. All men are created equal. Okay? All men are equal under the law, right? No man has a right to create laws to rule over another man, okay? And every man, this is a good one, just what we're talking about. This one says, no man has a right to be a judge, okay? But every man has a right to a fair hearing, you see. So no one has a right inherently to be a judge, but every single man has a right to a fair hearing. So when they ask you to go to a venue and they want to question you, you question them back as well. Say, fine, I'm going to participate as long as you give me some answers. Tell me your name, for instance, judge. Are you acting under your oath, for instance, judge?
They do you in your absence, to kick you out of court.
Well, if they do it in your absence, we have all the rules for it. You void it, you strike it out, okay? And there's case law after case law after case law of void acts, you see, so you can void them, okay? One sec. We'll come back to Q&A. Let me just go through this quickly, and then we'll do the Q&A, and we'll answer all questions, okay? So let me carry on. I'll jump a few more things just for time. Right, I was going to say that what we need to understand is this. There's three ways that you can deal with these claims, or there's three claims that someone can bring against you. So you're going to have a criminal complaint, and say, oh, you caused harm or injury to him. Someone can bring a civil claim, which is to do with breach of agreement, or, which is prevalent, is a commercial charge. So these charges, those are commercial. So you have to understand, when you see a document that says charge on it, it's nothing to do with statutory, nothing to do with common law, it's to do with commerce. We talked about earlier about a dog is a dog. A charge is a charge. So as soon as you see a document called a charge, you need to understand you're doing commerce. So forget about the acts and all the constitution and all this nonsense, deal with it commercially. So what we do is we do the commercial side only. I've tried the common law, it doesn't work. I've tried the statutory, it doesn't work. Okay? But the commerce works, because they're using what's called the Uniform Commercial Code, and that's international. And now what they've done is I can't say the word, they've made into statutes the UCC. Statutoralized it. So now the codes of the UCC have become your statutes, so that's what they're using on you now. But the rules apply, and it's to do with owning, disowning, commerce. So it's four ways you can deal with any claim. A charge is a claim. Somebody charges you, you can accept it, conditionally accept it, and you remain in honor, you're going to win your case. You can argue or ignore it, and you go into dishonor, and you're going to lose your case. So they bring you charges, and you start arguing about, oh, it was like this, the truth and facts, you're in dishonor already. When it gets to court, you're going to lose your case, regardless of what you say. Why? Because they don't listen to what? Truth and facts. You see? So you wonder, why? How come we lose the cases all the time? Because we are making the wrong argument in the wrong jurisdiction. The argument says charge. You see? It's a commercial term. It's a commercial process. You need to use commercial remedy as well. So if somebody charges you, you discharge it. You don't defend it. But we tend to defend it, you see. Okay? So we clear on charges. So when somebody tries to charge you again, what are you going to do? You need to discharge it. Okay? How do you discharge it? By remaining in honor and conditionally accepting the charge. So the way you draft your documents is this: I conditionally accept the charge upon proof of claim that, for instance, there's an injured party, or proof of claim of who you are, for instance. And that's, you leave it at that. It's one sentence. We tend to get into it too much. Keep it short, keep it simple. Okay? Accept the charges and say, I'm going to pay you if you tell me who you are. And how these charges created, because remember, charges are commercial. I'm going to go in and give you the 4 elements required for a true charge. So if one of the elements is missing, it's a false charge, you see. Okay? So, proceedings now. Proceedings are always in rem. When the corporation brings a proceeding against you, they're proceeding in rem, which is they're going against the property You see, they cannot proceed against you. Why? Because you're a living man or woman. They cannot proceed against your property because they are a corporation, you see. So proceedings are always in rem. Even when they write that name that looks like your name, that is not you. They're proceeding against the corporation in your name. That's all. So you can defend it at that level as well. So when they bring the charges against you, you could always ask them one simple question. Are these proceedings against the corporation called John Smith in all caps, or are these proceedings against a living man known as your name written properly without the caps? And they're stuck, you see. You stop the case right there. So you can stop this case in many ways. There's 1,000 ways to skin a cat. But it gets very simple. If you keep it simple, life gets easier. Okay. So proceedings are always in rem, remember that. Okay, and proceedings are always in three ways: criminal complaint, civil claim, or commercial charge. Now, because men and corporations have unequal status in law, you have to make it into a corporation. Now, you have to understand the word act as well. We're talking about dog and cat, you need and charge. You need to know what an act is. When they talk about acts of parliament, or a man acting as a judge. He's not a judge, he's acting as a judge. We need to understand English language. When I'm saying I'm acting as something else, I'm not that. So you see the documents, you're going to see whoever, John Smith, acting as a judge. He was acting as a judge, he wasn't being a judge. It's not an act. How do you know it's an act? Because they wear costumes. It's a game, guys. That's why they wear costumes, to try and spook you. Because we've been trained, if you see a man wearing a butcher's knife and a clipboard, now he's a professional. And if he knocks on your door with a clipboard and a butcher's, you think, yeah, he's got something, or a nice suit, then you listen to him. If you go to the court and they're wearing all these costumes and all this black magic, I'm going to swear about it, but it's to do with voodoo anyway. They wear all this black stuff. It's to spook you. They're actors, right? But the point is this. It's a stage. Actors invite you to go in there, but they have a script and you don't. The prosecutor has a script, your solicitor has a script, and the judge, they're reading from the same script. And you go in there with no script. And you're trying to be part of the action without a script. That's why you lose your cases, because you're talking nonsense. And they're reading from the script, and they understand each other. So you need to know, you either go in with a script or you don't go in there. You see, that's the whole point. It's an act. They're all actors. Okay? Don't take them that seriously. They're actors. Okay? Acts of Parliament, acting and sitting as well. When we talk about SITs in Magician's Court, okay? This is a funny thing. When you make a claim in the High Court, if somebody makes a claim against you, in the High Court, which is a superior court compared to Magician's Court, you have three options. You can accept the claim, which means you want to settle. You can defend the claim, which means you're going to go to trial, or you can challenge jurisdiction of the court. And that's the High Court. There are three options. When you go to the Magician's Court, those idiots, they say that you cannot challenge the jurisdiction. And they're the lowest of the low. How is that possible? You can challenge jurisdiction of the High Court. So you understand these actors. Don't take them seriously. Okay? People just believe them because they said so. They have no proof of anything that they're doing or anything that they're claiming. You see, they're bogus, rubbish people. Okay? What they've done is they've convinced you by using television and their movies that this judge is somebody who knows about the law and you don't. We all know about the law. Everybody knows what the law is. That he knows something that you don't because he's going to cost you. He doesn't know anything you don't. We all know the truth and we all know the law. The point is this: do we abide by it? That's the question. Most of us don't because we get swayed and we get convinced by these actors that they're something that they're not. Okay? So, a claim. Now, solutions. The solution for this is this. I'm going to give you a solution that I used many times for many people. Works all the time. This is to do with claims that have no injured party. Somebody just makes a claim and say, yeah, come to our courtroom, we're going to try you, and that's it. Okay. So, there's something called valid cause. People who study this stuff will know that before a claim goes into court, whoever's bringing the claim has to file something called a valid cause. That's the reason why you bring the claim. Valid cause is three elements. If one is missing, it's not valid anymore. If it's not valid, then the claim has to die. So three elements of valid cause. I'm going to give you those. One is violation. So you have to allege that somebody has violated your rights. Usually it's a legal right. So that's element number one, is violation of a legal right. Number two is corpus delicti, which is the body, injured party. So violation of a legal right, first element. Second element is there has to be an injured party. And third element, redressability by the court. So those three elements, critical. Number one, they have to allege the invalidity of the right. Anyone can do that. Number two is important, corpus delicti. If there's no injured party, there is no crime, right? So when you park your car on a double yellow line, it's not a crime, okay? But if you go to court, if you're allowed to go to court, you're going to be tried under the criminal procedure rules. That's the trouble. It's a civil matter, but where does it change and become criminal? You see, by the time you get to court, it's a criminal matter, but it's not, because a crime is what? Three elements. There's no injured party. The second element is missing. There's no injured party, okay? The third element is redressability by the venue. So the venue where you choose to put your claim has to be the right venue as well. For instance, if I bring a claim, somebody injured my dog, for instance, I cannot take it to a traffic court. It's the wrong venue, you see. So if you bring that claim against me, I'm not going to defend it. I'm just going to say it's the wrong venue, and your case stops there. You see, that's it. So it has to be the right jurisdiction as well. So when people take it to a magician's court, you have to challenge the venue, you see. Instead of getting into truth and facts, this happened and that happened, no. The venue does not have the delegation of authority to try this case, or to try me, a living man or a woman. That's it. That's the end of it, you see. So, okay, so without valid cause, there is no valid claim. That's the point I'm trying to get to. So valid cause has to be filed in court, which means somebody, a living man or woman, has to have a piece of some documents in a bundle, which they're willing to sign to attest to the truth of the documents, and then he has to file these documents in a court. That's valid cause. If it's not done that way, it's not valid, which means the proceeding is invalid. So you can kill the case at that point as well, by challenging jurisdiction, or by informing the court that you have no evidence that the claimant filed valid cause. So that kills it as well. Okay? Right, now.
Sorry.
That's all right. The process in a magician's court is like I said before, it's a Greek tragedy, it's a play. We are acting, okay? Everything is an act. So you have to understand every Greek tragedy play has 3 acts. There's always threes. It's always in threes, because it's voodoo as well. These are in numerology. We can discuss another talk. We can talk about why they use certain numbers. 3, 7, 7, 9, 11, all these numbers have significance, you see. So the number 3, first act is, this is where we lose our fights. It's the first act. The first act is this, the establishing of status of the actors. And that's where we lose the game. You need to establish your status. Before you start, you proceed, you need to identify who you are to the court, which is your living man, and you're not a corporation. And these are your rules. If they want to deal with you because they are corporations, you're going to give them your rules. So that's number 1. So you have to establish status. Number 2 is education, where they sit down and they're going to act. And then number 3 is the rendering of the final judgment. So those are the 3 acts, you see. When you go to a magician's court, the judgment has been done before you get there. Most cases anyway. That's why the judge sits there and is bored out of his head, because he wants you to finish quickly and go, because he knows what the result is. He's wasting his time. He's going to sit there and, oh, fuck it, just carry on quickly, because the decision has been made. Okay? So status is important. If you don't establish your status, they're going to jump into adjudication. So don't let them do that. Okay? They've tried that with me several times. Every time I go to court, the question is this, please tell us your name, address, and date of birth for the record. It's not a record anyway, but just tell us, because the magician's court is not a court of record, you see. And if you do that, that creates joinder. So what they want is the 3 things. Name, date of birth, and address. Name, because that's when your corporation was created. Date of birth is when it was created. You are incorporated, and the address is where you conduct business from. That is it. Once this has been established, it's called proof of agency. It means you're an agent of the corporation. And now they can try you under their acts, because you're an agent. And by your own admission, because you opened your mouth, and you said you have a name, and you have a date of birth, and you have an address, now you're an agent, and now we can deal with you the same way we do with all our agents.
They already said, they already told you when you, if it's a criminal who's been arrested, they've already told you that anything you say can be used.
Exactly. You see, they tell you anyway. The point is this. Excuse me. Because we live in a plane of what's called free choice. The plane we live in, no one can be compelled to do anything. If you do compel someone to do something, you violated natural law. So I have to convince you. That's why your consent is required and your signature. You see, whether or not it's by implication or by express consent, as long as you give consent, everything is good. So the reason you're being oppressed is because you've given consent to it. That's it. You see. So it's the plane that we live in is a plane of choice. Every single one of us has a choice to choose what they want to do or what they don't want to do. Except that you can do anything you want to do as long as what you do does not infringe on somebody else's rights or doesn't cause harm and injure somebody else, and you're free to do whatever you want. Okay? So, the act, remember to establish your status as soon as the claim is made. And this is on paper. Don't wait for it to go into court, because the process begins on paper. Remember, it's through the letter. So you're going to receive a letter in the post, usually front mail, and it's going to say something. It's how you deal with it at that point that matters, not in court, because the court is too late anyway. By the time you get to court, you're fighting and it's crumbling. You want to deal with it from the first letter, okay? You want to establish your status from the beginning. So when you go to court, if they take you to court after you've done that, you can produce your paperwork and say, listen, I explained to this guy who I was. I'm a living man. As far as I know, as far as I understand, your acts require my consent and whatever argument you have, and then you can produce it in court. Okay? So, important points are these. Incidentally, there's something called a PCN. I don't have a car and I don't drive, I don't have a license. There's something called a public charge notice, that if you park in some...
Penalty charge.
Penalty charge notice, yeah.
There's no fine.
I mean, even those three words, penalty, look at the legal definition of it, charge and notice, those three words, it just kills it. Just like that. There's no penalty to start with. If you're going to give me a penalty, we have to understand the rules to start with. And if I cross here, then there's a penalty. If I don't know the rules, you cannot penalize me. It's as simple as that. But in any case, a PNC is never, it's a notice, right? It's not a criminal complaint. So how can they try it in court? Understand? For there to be a trial, there has to be a criminal complaint. So how do they try these PCNs in court? They're not complaints. So you can kill it at that point. Say, excuse me, Your Honor, I have no evidence that a PCN is a criminal complaint. In that case, the case. It says notice. You see? So things have to be done properly. I don't answer to a notice. I'm not going to be tried under a notice. Guys, it's a notice, it's not a complaint. So the reason it's not a complaint is this. Anyone who puts documents in court, they have to attest to it. They have to write a statement saying that they have first-hand knowledge of the facts, you see, and then sign it. And that's the only way it's going to get through. You see, that's the only way it's going to get through. Who signed the PCN? Nobody signs it. So nobody has actually made a complaint. So how can they proceed? You see, those proceedings are null and void ab initio from the beginning. I don't even know why people participate. They even take this guy seriously. But anyway, that's something else. Right. Important points are these. A court can only gain jurisdiction over a living man or woman by something called effective service of process. That is it. How do you serve process? By hand or by a recognized process server, which is the post office or the people in the court. The people actually process servers. You go in there, you give them a document, and you pay them some money, and they can serve anyone you want. That's the only way you can serve. When these people frank mail, that's called mail fraud, and make claims by frank mail, you don't get into the facts. You let them know that they cannot serve legal process by frank mail, and that you're not going to deal with that stuff if they do it that way again. You see, if they don't serve process properly, tell them to put £7 the same way we do, go to the post office and register it and pay the £7. And that's proper service. That's what we do. Every time we write to them, we do it that way, you see. So a court can only gain jurisdiction by what? Effective service of process. When they give you a PNC or PCN or notice and say show up in court, and you go, then they accept that process has been served. Because if you read their rules, it says this. They have about 7 ways that you can serve process. The main ones for a living man or woman is by hand or by recognized process server. There are other means like lawyers do a DX, which is a document exchange. So they have a place where they go and exchange documents. There's electronic service as well. You can accept that if you want, but do not take it, because I know somebody who has accepted service by electronic means, and the police have sent him a warrant through WhatsApp. Yeah. Yeah, that's how stupid it gets.
That's hearsay.
Yeah,
It's not
exactly,
paper.
exactly.
No, it's hearsay.
Exactly. But it's to do with agreement, you see. It's to do with agreement. If I agree to accept service that way, then of course they're going to serve it. So you have to let them know how you accept service. I don't accept service by WhatsApp. If you want to write to me, put it in a piece of paper, write it by hand, put a seal on it, and then I'll accept it. Okay? But that's how silly it gets. Because the legal process is this. In the legal industry, anyone can express an interest on anyone else's property. That's it. So I can express an interest on your property today. That's it. It's up to you to challenge my interest. That's all. That's all there is to it. So all these people are expressing interest in your property, and you don't know what to do. And they're talking about common law, and they're talking about this stuff, and all these other things. And they're losing your cases. Because you don't know how to, I don't want to say defend, because we don't defend cases. We accept all of them. You don't know how to discharge charges. So you need to know how to discharge a charge. A charge is positive. A discharge is negative. When they put a positive, you put a negative on it, and that equalizes it when the claim is finished. If you defend, that's a military occupation business. Defend and attack, commands and orders, these are military terms. You accept that you are in a military occupation and you're an enemy combatant, and they can beat you up because you're an enemy combatant. That's the whole point. You're being duped into things that you don't know. You do not know. Okay? So, service of process. If the process has not been served effectively, your defense is what? You don't go into truth and facts. You let them know that I have not received an effective service of process. So I'm unable to participate in your proceedings. That's it. Finished. They have to serve it properly. So that's number one. If it's not served properly, it's called defective. Okay? And that's from the beginning, from the first letter. You see. So if the process is defective, the claim is invalid from the beginning. So always watch what's being sent to you. Read it. Is it being sent to you, or is it being sent to a nom de guerre, which is the all caps legal fiction? So this is what you talk about. You need to know who you are. Are they sending this letter to you, or are they sending this letter to a legal fiction? Once you know who you are, you know how to deal with it. You see, because you can defend your legal fiction, you can write on behalf of it, and say, yeah, I'm the trustee of this legal fiction, so I'm writing on behalf of the legal fiction. It's not me, but I represent it. You see, because that's your corporation anyway. For me, I've covered it in my name. That's what I do. So every document that I send out, I put a copyright mark on my name. So they can use it to conduct business the same way they do with everybody else's name. Okay? So, now, certificate of service. When you effect process, when I serve you process, okay, I'm going to have a certificate of service which proves that I've served you process, which means my process is effective. How do we do that? When you register it, you can go to post office online and see if it's been delivered. It's going to be there. It's going to say when it was delivered, from which post office, and hopefully see a squiggle as well, whoever signed for it. You make a print of it and you attach it to a copy of the letter, and that's your proof of service. They cannot prove that they served you anything under front mail, because they do thousands at the same time, you see. So their process is ineffective. You can produce a certificate of service. So every time they make a false claim, you write your defense, your discharge properly, you serve them properly, and then you keep the evidence that you've discharged it, and that's about it. That's the entirety of the game. They're always going to be at fault, and they're always going to be at commercial dishonor, because they're not doing things properly. Okay? So certificate of service, always keep your certificate of service. When you post it at the post office, you can have the receipt anyway. It's going to have the numbers. Those numbers, go online, check it, see it's been delivered, make a copy of it, and attach it to the statement that you sent out. Okay? And then, number 3 is the effective participation. Right. When you see, particularly traffic, you're going to see in the paper, it's going to say proposed proceedings. It's always proposed, you see. They're proposing, and they're inviting you to be a party to the proceedings. This is where you have to know what you're doing. So, in order for you to participate effectively, you need some information, which is called disclosure. As long as they don't disclose the information that you're asking for, you have no obligation to participate, and that's what it is. Okay? So somebody asks you, come to our courtroom and come and answer these questions, you have every right to ask them who they are. So I need your name, and I need to know your capacity, and whether or not you have legal standing to bring this claim. That's it. Or ask them, did you file valid cause with the court? That's it. And if you did not file valid cause, I'm not going to participate in your proposed proceedings. Look at the traffic paperwork. You're going to see, it says proposed proceedings. You see, they're proposing. Because, look, this is how they earn their living. In this life, there's two people. People produce and people consume, right? The people who produce nothing, but they eat a lot. They use other people's work. They're like parasites. The so-called government, they don't produce anything, do they? They produce paperwork. Whereas you have people who are builders, they make buildings. The people who are electricians, they create electricity. You see, the people who actually make things. They're the people we want. We don't want people who just produce paperwork. Government, it's of no use, you see. Absolutely no use. Okay, so, anyway, I tend to deviate when I get into government. Anyway, effective participation, that's the third point I wanted to make. So number one is this. The only way they can get jurisdiction over you is by effective service of process. If the process is defective, they have no jurisdiction over you. Number two is a certificate of service. If they don't have that, then they're going to proceed. You can always say, I wasn't served process. And if you want to do something called a statutory declaration, kill it as well. If you do that, they're finished. Okay? But that's the statutory side, that's not commercial. If you want to do statutes, so statutory declaration, you go ahead and write it down and say, I was never served process. And that kills the case. Okay, and number three was the effective participation. If somebody expects you to participate effectively in their proceedings, they need to disclose basic information that you're going to ask them for. They never have that. Okay, so, right, so I'm going to go, for people who like to research, I'm going to go briefly to case law. And we still, I've heard, because I'm with television, I know what's going on up there, but I know there's something called Brexit or something, that the European Union is being left behind and England is going to leave the European Union. However, the HRA, the Human Rights Act of 1998, is still active now until they repeal it. So you could always use that. So what I have here is from the European Court of Human Rights. So those case law is still valid. So this is to do with effective participation and fairness. 4 elements as well. It says the elements of fairness consist of 4 implied rights. Okay, so you have a right to effective participation, and the case law for that is TNV versus the United Kingdom, and you can get that online if you're interested. Number 2 is the right to oral hearing, okay, and that is Batani, that's European Court as well. The third one is the right to publicity, so you can bring anyone you want into a public hearing when they're trying you. Nowadays, you can bring people inside, it's just us, it's no. We want a public hearing, or the right for the applicant to claim that third-party persons and media be allowed to attend the hearing. And that's what the European Court as well is called RIEPAN, R-I-E-P-A-N, that's the case law. And the fourth one is the right to publication of the court decision. And also something called reasons for decision, which they never give you. Every time a court makes a decision, they have to give reasons for it. So you could always ask that. What's the reason for the decision? And that's standard. They're obligated to give it to you. So that's number 4. And that's Prito and others v. Italy. That's European Court as well. So that's, if the 4 elements are lacking, it's not a fair hearing. Okay? Now, I'm going to jump, and other points. And, about the striking out. Somebody said earlier on that if you don't participate, they're going to rule in your absence. This is a solution. What we use is this. There's something called CPR, the procedural rules, right? Because the entire legal industry is based on procedural rules. It's not based on law. We have to understand that. They leave the law there by itself, and they base everything they do on procedural rules. So if you do your things as well according to their rules, they're going to lose all the time. To do with this thing about where they come to judgment in your absence, there's a rule 27.9, if you need to look it up. It's CPR 27.9. So what you need to do is this. You give notice in advance under rule number 27.9 that you will not turn up for their unlawful hearing, and then you give the reasons why. Because before that, you have asked them the questions with the one answer, and then you're going to write a statement, and with the statement, he's going to say the rule that you're using. So I'm going to use the rule 27.9 to say that I'm not going to come to your hearing because I have not received disclosure, or I have not received the information that I asked you for. So therefore, I am unable to participate effectively in your proposed proceedings. And you leave it at that, okay? If they rule in your absence, you use it's the same CPR, but it's 0.12. So it's 27.9 to make the notice, to give notice, and 27.12 to strike out any judgment that's been given in your absence. So that's the CPR that you need for that. Okay? So that's what you do. Somebody makes a claim against you, you ask them a few questions, they don't answer, they go to court and they make a ruling against you, you go and strike it out based on that. The fact that it did not allow you to participate effectively and did not give you a fair hearing. That's the law.
But also the Magistrates Act 1980, section 14, if you did not know of the time of the hearing.
Yep, that's true as well. So if you want statutes, there's a whole bunch of statutes that you can use to stop these people. The trouble with statutes is this much. You see, you can read it, then it's millions of them. It drives you crazy studying it. You see, and they're creating more every day. So it's very difficult. I did studies for about 2 years and I gave up. So I just went to commercial side. It's straightforward. But statutes, some people use it, but you have to know exactly which rule you're using. But for strikeouts, that's the rules. 27.12 for strikeouts. Yep.
It is right, we went into court, we asked for, obviously, what case finding file. We just don't give it, we even asked before we went into court.
Right.
And they just don't give it.
Did you use the rules, procedure rules?
Well, it's 37 or something, but I just asked for the case management file.
Yeah, okay, the trick is this. With these idiots, the way they operate is this. If you ask them, what's your name, they don't tell you. Okay? But you have to ask them, excuse me, what's your name according to the Name Asking Act of 1973? And then they'll tell you. You see, that's how silly it is.
Yeah, it's because we don't know it.
Exactly, it's about procedure rules.
Ask them first, though.
Yeah.
Right, ask them first.
Yeah.
And we got a couple of letters back, and then there was a few other bits and pieces as well. So I didn't give us what we wanted.
Exactly. The point is this, I've been doing this for 8 years now. I have never ever, except for the one judge who gave us his oath, I have never ever received anything from these people. Because their very existence is a fraud. We won't get into that today,
So
but...
if I tried doing this rule 27.1, basically, and having it, basically because I wasn't allowed proper due process.
Yeah.
I wasn't given like the means and everything like that.
Yeah.
Now, will that apply? Will they just kick it out then? Because
No, it's not about they, it's about what you're doing.
Yeah, well, they put 6 points on my license and they put a fine on me, and now they're sending the court team management after me.
Right. The point is this, okay, we won't get too much into that. To be trafficked. If it's to do with traffic, they're going to deal with you the way they're dealing with you because there's a presumption of agency. You see, because you hold a driver's license. You see, a driver's license is used for commerce. As long as you're doing commerce, you have to pay the people who allow you to do commerce. Because you're trafficking, you see. As long as you're trafficking, you have to pay them some money.